is Ms. Litchfield, are you going to introduce the Homestead Act? Come on up. Just do with the signage.
I do actually have some testimony from a couple of constituents. May I hand it over to be passed out?
So Melissa, Representative Litchfield, if you don't mind introducing yourself for the record and who you represent.
Yes. Good morning. My name is Representative Melissa Litchfield. I represent the towns of Brentwood, Danville, and Fremont, District 32. Chairman Lang and fellow committee members, thank you so very much for hearing this bill this morning. So the homestead right is a bill that is actually, it's a law that's actually already on the books. I am just looking to update it to match the current market values of the homes in the state of New Hampshire. So right now, well, the gist of the bill is basically it's to protect you if you have, let's say, medical bills or a civil suit. Back in the day, if there was some type of, let's say, auto accident, you'll see in the testimony from one of the attorneys, an example given was a ski accident where it was simply an accident. And the person that was injured felt that going after insurance wasn't enough and they wanted to go after this person's home. So my goal in this is just simply to protect the roof over your head. This is why it's called the homestead right. It basically covers a home up to $1 million. Right now, it's at $120,000. That's the law that was on the books. I think it was updated maybe in 2017 or 2018. So right now, it's $120,000 for a single person. If you're married, it doubles it. My feeling is, though, the cost of a home is the cost of a home. So I don't really think that you should be penalized because you're single and not married. That's why I'm looking to bump it up to $1 million. What I did in looking at this law is I actually scoured the laws in all 50 states just to bring in the best of the best. So some of the things that I put in for bumpers, I did add in that the home could be in a trust. But I said the primary residence, it has to be your primary residence for at least the previous 12 months. We did say, though, that if you have to sell your house for any reason, if you're in this litigation, you do have 6 months to buy a new house, only because it's very hard to find houses these days. We do have a housing crisis. Let me see. It does not cancel or erase debt in any way. You still owe the money. It just simply protects the roof over your head. There are also exemptions in here that state you could still be forced out of your home for not paying your property taxes, for not paying your income taxes. If you don't pay your mortgage, those are things that are not exceptions. I know that we may hear at some point, possibly maybe from some lobbying groups that may be uncomfortable with this. I do want to say that if certain companies giving loans are uncomfortable, they can simply have the person getting the loan sign off that they're exempting themselves from this. So the other thing that I just wanted to finish off with, please, in doing this and in wanting to move this up to $1 million, I simply went around the state, and the home values have changed significantly, even just between 24 and 25. So Portsmouth, New Hampshire, we have sales price, this is January 2025, $895,000 was the median. The list was $1.3 million. Atkinson, 125, the median list was $1.3 million. Windham, $895,000. I have Alton, median sales, $785,000, but median list at $1.498. So anyway, I could go on. I'm trying to think. Newbury was $530, Rindge was $809. So when I originally presented this bill, I had been approached by a constituent in my town. And they referred me to a secondary constituent attorney. So I brought it forward on behalf of two people. It's interesting because they both vote very differently. So I honestly thought this was going to be a bipartisan bill. I had no idea that it actually came out of the House partisan. It went down party lines. Maybe about 20 people on the Democratic side did cross over. And my understanding is the one issue they were looking for the bill to be at $500,000 versus $1 million. The concern there is though, sure, that's great. It looks nice. It feels good if we up it, but it's not really protecting everyone if our home values are really worth $1 million. So we just want to do what's right. If you research it, there are other states out there that have unlimited, to be perfectly honest with you. There are others that have $1 million as well. And I think, I just want to make sure I have some notes. I think that's just about it though. I covered the following exclusions: the mortgages, tax liens, mechanics liens, labor performed, judgments arising from forfeited bail bonds or domestic support obligations. Let's see. Yep, the exemption also extends to the full value of the property if debt arises from a catastrophic or terminal injury, illness, or medical bills. Like I said, it does not cancel or erase debt. It just keeps an individual from being forced out of their home. And I think that covers all of it. The owner must be a person and not a corporation, although we discussed it can be the beneficiary of a qualifying trust. Exemption does not apply to claims in existence at the time of acquisition of the homestead. So that's it. Thank you.
Questions from the committee? So I just have one. Do you know what the median home value for New Hampshire, the median home sale price was in New Hampshire for 24?
When I did this, it was a couple months ago, and I want to say, I don't remember if it was median or average that I looked up at the time. It was like 489, but
How much?
about 489 a couple months ago. And that was one thing that I did present to the municipal committee over at the House. But the concern was that as I started to dig deeper, there were so many different pockets in so many different areas in New Hampshire that it just varied so vastly. You know, you could have Rye where you're at a couple $1 million, right? Where you could have somewhere up north that's 500,000. So that's why we went with $1 million.
Any further questions?
May I add one more? I'm sorry.
Yeah, comment.
Thank you. The other thing that I wanted to say too is that when I put this bill forward, there are no co-sponsors. I know sometimes people tend to read into it, but it was just one of those where literally I was approached right after the election. So I put it in. And as we know, OLS was just incredibly busy this year. And it was easier just to put it through under myself. That was all.
Great. Thank you very much.
Thank you.
Next up, we'll have, what do we got here? Leonard Deming. Turn your mic on. Turn your mic on, the little red button, hit it. There you
Is
go.
it on now?
Yep.
All right. I'm here representing debtors in bankruptcy, essentially. I've been doing that for the past 40 years, and I'm urging the passage of a much higher homestead exemption, consistent with what's being offered here. By way of history, having done this for a long time, it was routine for debtors in bankruptcy to assert that the non-owning spouse of a marriage and living in a home had a homestead exemption of an additional $120,000. That was always the practice in this state for decades, until the case of Brady versus Sumsky decided in 2023, for which I actually represented the debtor. The court at that time determined that there was only one homestead exemption for the owner. And what this did was expose many people to losing their homes. And I think it is essential that the homestead exemption be increased to enable people to retain their homes in the best possible situation. The increase in values of homes has rendered it very possible for trustees in bankruptcy to take homes away from people. If you're not familiar with how the practice works, the instant a person files a Chapter 7 bankruptcy petition, the Chapter 7 trustee becomes the legal owner of everything the debtor owns, right down to their underwear. And they're enabled to take homes where the homestead exemption does not protect them. This would enable them to do that. New Hampshire, this statute would enable them to be able to retain their homes if the homes are worth less than $1 million. The median family income for the state of New Hampshire is among the highest in the country, anywhere from second to fifth highest in the country, which means we have large median family incomes. The value of real estate has increased dramatically. And the result of that is people are losing their homes or being forced to file Chapter 13s, which in the end, which is a repayment plan, which in the end doesn't work. And then they end up having to exit Chapter 13, convert to 7, and lose their home. This obviously contributes to homelessness, which we'd like to not have. The provisions in this statute are generally sound in terms of how to approach this. I would note that that the clause versus reinvesting is an important clause in terms of protecting the proceeds from the sale of a house for 6 months. There is also that provision in the federal code, but here with the state exemption, we have a ruling in the New Hampshire bankruptcy court that states that as soon as somebody sells their home, that money goes into a bank account, it no longer benefits from the exemption. And having that exemption, perhaps clarifying that if the money is placed in a separate account, so that it's clearly the proceeds, that person would have 6 months within which to reinvest and thereby maintain their exemption and be able to reinvest within the state. There are already protections in the bankruptcy code, particularly in RSA 522P, which prevents debtors from coming into the state and buying a home and then right away filing for bankruptcy protection. That's called the Burt Reynolds Rule, which was enacted by the federal government after Burt Reynolds went to Florida and utilized the the absolute homestead exemption for all homesteads and enabled him to simply put all of his money into a home and protect all of his money. This statute already does that, but also the federal government's 522P protects that from happening to the extent for a period of over 3 years in terms of reinvestment and coming into the state and trying to do that. The other aspect is the notice. I noted in this proposed legislation that they're talking about notice in writing to the sheriff regarding the homestead exemption, failing which the exemption is not allowed. This seems to me to be a product or an aspect which can create litigation, especially in terms of how the notice is given. Does somebody walk into the sheriff's office and hand them a letter? Do they send it, certified mail, return receipt requested? I think the notice has got to be clear. Otherwise, we're going to be creating additional litigation as to whether the notice was ever given. This particular provision, I think, requiring the sheriff to be given that notice, I think is superfluous because the statute already gives the exemption, whatever that may be. And I believe the sheriff would have to respect that regardless of any notice given the sheriff. The public notice is already given in terms of the reporting in the Registry of Deeds. I'm just looking at my notes to see if there's anything else I wanted to mention. In any event, I urge an increase in the homestead exemption to protect people in their homes, to enable them to, at this point, if we file a bankruptcy today and a person has over $120,000 in equity, they are subject to losing their homes to a Chapter 7 trustee. And this is happening more and more in the District of New Hampshire.
Questions from the committee? Senator Roosevelt.
Thank you. Thank you, Mr. Chairman. Thanks for taking my question. Do you know how common it is in New Hampshire for let's say, two people who are married to not mingle their finances so that only one is declaring bankruptcy and not both?
Do they mingle their finances?
Mhm.
It's not unusual for a spouse, for spouses to do one or the other. Very commonly, I have spouses come to me who do not mingle their finances. And of course, other people jointly own everything. So there's no real certainty as to when somebody walks into my office as to which they're doing.
Thank you.
Any further questions from the committee? Seeing none, thank you, sir.
Thank you.
Peter Tamposi.
Good morning, Mr. Chairman, Senators. I rise in support of this bill. I'm an attorney in Nashua, former adjunct professor at the law school over here. And I mostly represent small businesses and entrepreneurs. And there's an interesting connection, I think, that's important between small businesses and this legislation. And it is that small businesses are really the cornerstone of large parts of the American economy, and we want to encourage small businesses to take risk. And if there's not a robust bankruptcy system behind them, they're not going to take the risk and undertake starting small businesses. In many parts of Europe, there's not a robust bankruptcy system at all, and if there's a business failure, it's often results in the owners losing their house and losing every opportunity to start a new business. That's not the case here. And the fundamental cornerstone of the bankruptcy code is the homestead protection. It's enshrined, obviously, in state and federal law. But we're I think, behind the times having the low homestead protection that we have now, and it's inconsistent with the value of properties, as Attorney Deming just demonstrated. I also want to bring the perspective of the increased risk that small businesses face through merchant cash advance loans. This is a new type of lending arrangement where we see interest rates of 30, 40, 50% interest, often repaid in 1 or 2 years. And I've seen dozens of companies have to file bankruptcy because of these merchant cash advance loans in the last 2 years. It's a sort of new phenomenon. It's a very easy way to borrow money, but it results in an extraordinary amount of debt load on small companies. And what I've seen, my clients have seen, is their businesses being literally sucked dry by these MCA lenders, and then they are left with filing a personal bankruptcy. And oftentimes these are entrepreneurs, very hardworking folks who've spent their life trying to achieve the American dream and buy a home and pay it down as quickly as possible, as we're always told we should do, right? Pay down the mortgage as soon as you can. And what they're left with is a home that's too valuable compared with the homestead law. And so they've done everything right, but they took a risk as a small business owner, and now they face losing their homes. And I've seen it again and again, and it's really a unique pressure that small businesses owners face, and the homestead is the backstop to prevent them from ultimately from losing their homes. I also wanted, so I do support the bill. I also come at this from the perspective of a director of one of the newer banks in New Hampshire. I think maybe the newest bank in New Hampshire. But I note that this bill does not affect mortgages. Every mortgage contains a waiver of homestead rights. So there's statutory protections in the bill, but also in the contractual protections of the mortgage. So this is I think the increase that's suggested here is not going to adversely impact mortgage lenders because they have a contractual waiver of homestead rights in every mortgage. So this, in my view, this really protects the small business owners, the entrepreneurs, as well as folks who incur medical debt, as Attorney Deming was outlining, and I strongly support the bill.
Thank you. Questions from the committee? I have one.
Thank you.
So looking at, on page 1 of the bill, section, oops, sorry, I have a question for you. Sorry. So looking at page 1 of the bill, section 4, there's notwithstanding paragraph 1, which sets a cap. The full market value of a property may be claimed as a homestead right if the debt for which the attached or levy is sought is a result of unpaid medical bills or other debts. So we're excluding all medical debt from any collection relative to the home. Is that what that does?
In my view, that it doesn't waive the debt, it just protects the home.
Protects the house.
Right,
the lien,
yeah,
the
that's
levy,
exactly right, yep.
And it doesn't matter what the value of the home is or anything else by that section.
That's right, and I'm also, yeah, as I said, I'm a bankruptcy lawyer, so I represent a lot of small businesses, but I don't typically see medical debt that's that extraordinary. The more what I see in my practice is personal guarantee obligations related to business failures. That's the debt that tends to be 100, 300, 800,000 bucks. Medical debt rarely, in my experience, gets that high. So I support this language, but I don't think it's going to come into play, frankly, very much, because I don't see medical debt typically getting that extraordinarily high.
Thank you.
Yes.
Thank you, Mr. Chairman. Thank you for taking my question. On line 21 of page 1 of the bill, it says the beneficiary of qualifying trust. What kind of trust is a qualifying trust under this? Is it a simple trust or both a simple or a complex trust?
Well, that's a good question, and what we usually think of the use of trusts for asset protection. There's really two kinds of trusts. There's a what we call a revocable trust, and then there's a permanent trust or an irrevocable trust. So a revocable trust is a simple trust that's used to avoid probate. And you put your assets, and I recommend it if you don't have one. You put your real estate into the trust, put all your assets into the trust, and then if one of the married couples passes away, or the last remaining person passes away, all the assets of the estate can flow to the beneficiaries without having to go through probate court. And I think that's what's meant by a qualifying trust. So it's not meant as a trust that's set up to avoid creditors. It's not meant as a trust where you give your money away or your assets away permanently, like an irrevocable trust. I think it's a simple ownership of real estate where you still maintain control of it. You act as the trustee in one of these trusts, a revocable trust. So you really still have control of the assets. It's just a function. It's just a way to avoid the probate process.
Oh,
Is that something we should clarify? That it's a revocable trust under, I don't even know what the RSA is.
Well, I think that's a great question, because it does, in my view, we want to, as Attorney Deming said, we want to avoid litigation regarding the language of the bill. And so I think modifying that to say, or at least either have a definition of what a qualifying trust is somewhere in the bill, or call it a revocable trust.
Okay. Thank you.
any further questions from the committee? Seeing none, thank you.
Thank you.
Our last speaker is Ryan Hale. Sure, how about it? Just make sure you introduce everybody.
Excellent. Chairman Lynn, honorable members of the Senate Ways and Means Committee, thank you for the opportunity to provide testimony on House Bill 617 relative to the homestead right. For the record, my name is Ryan Hale. I'm Vice President Government Relations for the New Hampshire Bankers Association. And with me today, I have Rob Dietl, our outside general counsel from the Gallagher firm here in Concord. New Hampshire Bankers represents 40 members banks across the state, employing around 6,000 employees. While we appreciate the intent behind this legislation, namely to protect individuals and families facing financial hardships, we must respectfully oppose the bill in its current form due to the excessive increase of the homestead exemption amount. Increasing it from 120 for an individual, 120,000 to $1 million represents a 630% increase and is a dramatic shift that is not aligned with the historical and incremental approach we've taken in the past. And just to reference the past increase back in 2015, the increase went from 100,000 to 120,000, and at that time the median sale price was $240,000 for a home here in New Hampshire. And to answer your question, Senator Lang, the median sale price back in 2014, quick search showed it was $514,000 here in New Hampshire. Historically, these changes to the homestead exemption have been modest and responsive to economic conditions, inflation, and the housing market, which these historical numbers show. The current proposal, however, represents a significant departure from that precedent and raises some concerns for us. It does disrupt the balance between debtor protection and creditor rights. The proposed amount far exceeds what is needed to protect most primary residents here in the state. And a more appropriate approach, in our opinion, would be to raise the exemption from to 250 to an individual and 500,000 for a married couple. So in conclusion, we would urge the committee to consider scaling back the proposed exemption to more reasonable and historical consistent approach. And at that point, I will end my testimony and happy to take any questions. And again, we have my outside general counsel, Rob Deedle from the Gallagher firm, who can answer these very technical questions that committee members may have.
Great. One second. Senator Pearl. Senator Pearl, we're still behind. We're on the first bill of the day. So if you have to go back to your committee, I can have someone come get you if you want to testify. What's that? We have another bill in between and then the one you want to speak to. So I'm guessing it'll be at least another half hour or more. I'll send somebody to chase you. Sorry about that. Questions from the committee? Senator Roosevelt.
Thank you, Mr. Chair. The way I read the bill, the exemption applies to the homeowner's equity in the home, not the full value of the home, except if it's about medical debt. I'm just trying to think of if I know anybody who has $1 million worth of equity in their home. I probably do, but I can't think of who they are because I think most people have mortgages. So am I right that this really is about the equity? It's the person's ownership interest?
I think you're generally correct, Senator Rosenwald, but in the sense that the protection is against the sale. So my understanding has been that the amount that's set in the bill is the amount that's going to be protected so that creditors can't go in and force a sale of the home with respect to that amount. So their actual ownership interest is limited, obviously, by what their equity is in the home. But I think for the purposes of thinking about the mechanisms of actually attaching and moving forward with a sale, I think the number in the statute is what's going to control, if that makes sense.
I'll follow. Thank you. So if I own $1 million home and I have mortgaged 80% of it, when it gets sold, the bank gets 800,000 back, and I get 200,000. Is that
Right, you're
correct?
going to be limited to get back whatever your equity interest is. This doesn't add on to that in any way. Ultimately, when it ultimately is sold down the road at some point.
So I'm sorry.
Good, keep going.
Unless I've bought my $1 million house with cash, I'm not going to have $1 million of value in my home for the creditor to attach.
Correct. It's going to be protected by the mortgage is going to take priority over what the creditor is going to go in and try and attach against.
One more, if I
Oh.
could. Would, in that case, the creditor, I guess you'd call them, be able to attach the lender's interest?
No, Senator.
So that 800,000 is never going to be,
The scenario you're describing, I think, is going to be the most common scenario, which is somebody has a home that has a first priority secured mortgage on the property, and that secured mortgage will always take priority.
okay.
And I think one point of clarification, I may have misheard, but I believe Ryan may have said that in 2015, the median home price was 515. I think what he meant to say is currently the median home price is 515.
Yeah.
In 2015, when I was involved with the Bankers Association on the last round of amendments, the median home price was approximately 240,000. And there was a policy decision, I believe, made at that time to try and have the combined value of two spouses reflect what the median home price was. And that was actually a pretty significant jump in policy. Historically, the amount of the homestead exemption, based on my research, was well below what the median home price was. So, for example, in 1977, my research was that the homestead exemption was $2,500 per person, and the median home price at that time, according to HUD data in the Northeast, was approximately $51,000. So there was a significant jump up in 2015, and I think the number that the Bankers Association is looking at in terms of the concern with $1 million is that now that's going well above and beyond what historically the homestead right has existed for the purposes of it.
Yes, just
One more question.
Thank you. What if I took a home equity loan against that 200,000 of equity I have in my house? Would that be subject to attachment by creditors?
The home equity loan and the first mortgage, they're all going to be in the same position, which is they're not going to fall within the homestead right in the normal course because there's going to be a waiver within the mortgage documents themselves. And the statute also speaks to an exemption. And I think the broader concern from the banking perspective is that banks are not always, frequently they're sitting in the position of a secured creditor, but not always. And so just like any other business, there's going to be scenarios in which they may have unsecured debt, which the homestead right is then. That's where that's going to get implicated.
Thank you.
So I'm going to follow up on her $1 million home with $800,000 in debt and $200,000 in equity. The other piece that this bill will do is, again, in a case of a person, if I understand it, and just correct me if I'm wrong, case of a person is in that situation, they have a failed business venture that has a significant debt. They realize they got to change their lifestyle because they can't afford the lifestyle anymore because the business failed. And so they sell their home, they make their $200,000 that they get to keep in their equity. They're able to then protect that equity, be able to buy another smaller downsized home. And that's what this bill would allow. The protection of that $200,000 debt from attachment so that they could reinvest within 6 months into another primary residence and not have that $200,000 attached.
Yeah, and that's correct, Senator. And that's a significant new change that's intended to, I think, facilitate exactly what you're describing. And Ryan can correct me if I'm wrong. I don't believe we have any concerns with that aspect of the bill.
No.
Any other questions? Seeing none, thank you, guys.
Thank you.
Is there anybody else who wishes to testify on House Bill 617? One more person? Can I get you to make sure you sign in beforehand, after, when you're done?
I did. I should be on the paperwork.
Oh, it might be another sheet of paper back there.
Good morning. My name is Malcolm Blackwood. I'm also a bankruptcy attorney. I help people file for bankruptcy. I've been doing that for almost 25 years. I've taken thousands of people through bankruptcy, and I'm here very much in support of this bill. This bill is a very good thing. As someone that helps people in financial distress, I've had a lot of conversations in the last few years about my inability to help people because they own more home than we're able to protect because of the $120,000 homestead exemption. So I've heard some great thoughts here, a lot of numbers, and I just kind of want to share this story from the perspective of a couple clients of mine, two widows in particular. One widow purchased her Manchester home in 1958, where she still resides today. I think it was about a $2,600 purchase. That home's worth about $400,000 today. And when I was engaged by this widow a few years back to save her home from a foreclosure. It was greatly complicated by how low the homestead exemption is. It was difficult. It took multiple bankruptcies. We were in the end able to save her home, which was very exciting. Just a couple blocks up the street from her, Manchester, is another widow client of mine. Purchased her home in 1976 here in Manchester. Husband passed. There's a lot of credit card debt from a daughter that had some addiction issues and was an authorized user on cards. There are now judgment lawsuits against her. I've been trying to help her for years, and there's literally nothing I can do to help her because she owns a house that's worth $400,000. She has debt of about $100,000, and now she's got multiple $25,000 judgment lawsuits against her. There's nothing I can do for her. All that I tell her is the homestead is woefully low. You need to contact your representative. You need to contact your local senator. I cannot help you. This is a great bill. I appreciate Representative Litchfield bringing this forward. If this goes through, I will be able to help those people. These people can protect their homes. I bought into that same neighborhood with these two widows in 2002. My purchase price was $200,000. Those homes are $400,000 now. The homestead should be a sufficient amount for a widow to protect her four walls, her roof, and her little patch of land. We're not there. This bill gets us there, and I'm just really thrilled to see it before this committee and processing through, because this is something that's really needed for people in trouble. I mean, the people I'm trying to help retain their homes, I tell them, and I think this is 100% true, if you lose your home, you're probably never getting back into one. So, thank you. I appreciate it.
Thank you, Mr. Chairman. Thank you for taking my question. I do represent half of Manchester. So my concern about the bill is that the $1 million limit, like on it. Would $500,000 be more appropriate for a bill like this?
I would be supportive of $500,000. I think if the homestead individual is doubled from 120 to 240, that's going to generally enable most of the people that I've engaged with over the years to protect their homes. I think that would be absolutely a reasonable compromise on this. The million's a large jump. Like, I get it. I mean, there's single family homes in the southern part of the state that are $750,000. So should that person not be able to protect it because they're single as opposed to a couple? I'd say that one's probably above my pay grade, but I think if we simply doubled the amount of the homestead exemption, that it would solve the problem of helping the people that I'm unable to help, who, are the voiceless people. Everybody seems to have an advocacy group except poor people. So I'm happy to speak for them, and I appreciate the question and the concern. And I'll just say this as a general point about bankruptcy. As someone that files a lot of these, nobody wants to end up in bankruptcy. Nobody planned this. Nobody's shirking responsibilities. It's a humbling place that nobody wants to be. And if we can enable people to protect their homes and do this with a modicum of dignity, that would be a much better result. And that's always been the lay of the land for the 25 years I practice here in New Hampshire. The home values have gone up, the homestead hasn't. We've unleveled the playing field, and that's what I hope we're rectifying here today.
Thank you. Showing what I don't know about bankruptcy. This bill only applies to married couples, but I think there are a number of cases where unmarried individuals purchase homes together. In a bankruptcy proceeding, do you have to be married for the bankruptcy to apply to both people?
Non-married couples cannot file a joint bankruptcy, but non-married couples can both have ownership on a home and then would have a homestead on a home. So it's very common for us to have a couple where they're not married and one's in bankruptcy, they both own the home, they both enjoy the homestead.
Should we think about striking the words married couple? If we want to protect people from becoming homeless, and say something like two people jointly owning a home.
I've only seen this language this morning. I don't see anything in here that's going to prejudice single people versus married people.
Further questions? Seeing none, thanks, sir.
Thank you, I appreciate it.
Is there anybody else who wishes to testify to House Bill 617? Sorry. So, no, seeing none other people wishing to speak, we'll close the public hearing on House Bill 617. We'll take up House Bill 647 next. Representative Popovic will be introducing, and I open a public hearing on House Bill 647.
Thank you very much, Mr. Chairman, members of the committee and staff. I'll try to be very brief because I recognize how your schedule already looks like. This is a reasonably straightforward bill that came to happen because of last fall's statutory created committee that looked at the revenues for Fish and Game. And one of the concerns expressed during those discussions was that the fee for a lifetime license that can be issued to a newborn, to an infant between 0 and 1 years old, has been statutorily set to $300, while all the other fees can be set by the executive director of the Fish and Game pursuant to an actuarial study. The concern is that the 300 value, the 300 fee may be too low to actually cover the cost of the license. If we look at the resident lifetime license rates, the 16-year-olds would have to pay $1,565 for the same license. Obviously, there is a time value of money issue here. I don't want to get overly geeky, but hey, it is ways and means. And there is also the fact that potentially quite a few of those kids may move out of state and never apply for a license. So there are issues there, but we felt it would be more prudent to allow the director to set those rates, again, pursuant to actuarial studies. This program has been a very significant help to Fish and Game by providing them with revenue that is held, separately to cover for the future, licenses they have to issue, but they are approaching the time when they are going to start issuing those licenses, and we wanted to give them a bit more flexibility. The bill passed 15-0 in the policy committee and was a voice vote in the House. And I'm all set, obviously happy to answer any questions.
Questions from the committee? Senator Fenton.
Thank you, and thank you for taking a quick question. So we currently have a lifetime fishing license,
Yes,
hunting license?
yes,
And follow up, do you know what that current rate is? Is that what-
yes. It varies by age. It starts from $1,565 for 16-year-olds, and I'm talking the combination hunting and fishing. There are various other combinations, and it decreases. For example, at my age, I'm 57, I would only pay $530 for the same license, and it goes all the way down to a rather optimistic age of 84, where it would cost $9.50. So it's again based on the expectation number of years that license would be used, and it's an attempt to just calculate the appropriate amount to charge once instead of having people apply every year. It tends to be a bit frustrating, the process.
Thank you.
Any other questions? Seeing none, thank you, sir.
Thank you so much.
So Senator Fenton, on the fiscal note, the last paragraph has, I think, that information you're looking for. You were just asking about, gives the numbers. Is there anybody else who wish to testify on House Bill 647? Seeing none, I'll close the public hearing on House Bill 657. Before I take up the next bill, I'd entertain a motion to go into executive session. It's been moved by Representative Senator Rosenwald, seconded by Senator Sullivan to go into executive session. All those in favor say aye.
Aye.
All those opposed say nay. Well, so I'd like to take up 647. I think there's no opposition to the bill. I think it's in alignment with our other actions where we're moving some of these fees and allow them to use actuarial studies to decide the cost. And that's what this is looking to do, is to give the executive director the ability to adjust rather than have it set hard in statute. So I'd entertain a motion off the pass if someone wants to make it.
I'll move it.
So it's been moved by Senator Rosen.
Discussion.
Moved by Senator Roosevelt, off the pass, seconded by Senator Sullivan.
Quick question.
Yep.
On the hearing, we have a non-germane amendment. Is that for 658 or is that for a different bill?
The non-germane amendment is for a different bill. Notice for a different bill. So to move and second for, at least for discussion purposes, not a pass. It's open to further discussion. Senator Rosenwald.
So I don't have any issue with this, but I just simply would note that there are plenty of areas where we set fees in statute. And as you know, looking at House Bill 2, you're seeing a lot of them doubling or increasing by a lot. So I don't know how different departments decide whether to do it by rule or do it in statute. I think it's probably better in rule, but we have more control if it's in statute, but I don't have,
So this bill
I
came
don't
out
have
of
any problem.
House Fish and Game, 15-0 was
I
put
know.
on the consent.
And Fish and Game
Supports it.
is looking for, but
All right, so the motion of auto pass. Any further discussion? All those in favor of auto pass, say aye.
Aye.
All those opposed, say nay. Ayes have it, and the entertained motion for consent.
yes.
Been moved for consent by Senator Rosenwald, seconded by Senator Fenton. All those in favor of consent, say aye.
Aye.
All those opposed, say no. Ayes have it, and Senator Rosenwald, you get the opportunity to take it out.
Oh, I love it.
Entertain a motion to come out of executive session.
Second.
It's been moved and seconded to come out of executive session. All those in favor, say aye.
Aye.
All those opposed, say nay. Ayes have it. We are out of executive session. And I will open up the hearing on House Bill 658. And I'm waiting for the sign-up sheet to see who's here to testify. Yes, please, would you mind? Representative Baker, to introduce, I believe. All yours, sir.
Thank you, Mr. Chair. Okay, the HB 658, interesting title. It's a raising the cap on certain reimbursements from the Oil Discharge and Disposal Cleanup Fund and reauthorizes the collection of oil import license fees and adjusts the fee amounts. Again, for the record, my name is Mike Edgar and I represent Hampton at in the House here. And I also am a member of the Oil Fund Disbursement Board. Thank you, Mr. Chairman and committee members, for allowing me to introduce HB 658 today. This bill impacts the Oil Discharge and Disposal Cleanup Fund, the ODD, which is managed by the Oil Fund Disbursement Board. And also it impacts the Oil Pollution Control, the OPC Fund, which is managed by the Department of Environmental Services. Okay, I'm going to go through the explanation of what the funds are and what the bill's about. And a lot of this was provided by DES. What the ODD fund does, the ODD fund supports New Hampshire citizens and businesses by providing funding to remediate oil contamination at petroleum storage facilities, which include home heating oil tanks, gas stations, and other businesses that store, distribute, or consume petroleum. The remediation of these contaminated sites protects property and drinking water sources. The remediation of these contamination sites allow for property transactions to occur in a timely manner, keeps business properties in productive use, and aids in moving redevelopment projects forward. Additionally, the ODD fund provides a mechanism to satisfy federal and state financial responsibility requirements for owners of underground storage facilities. The ODD fund provides this support through excess insurance coverage to owners of compliant petroleum storage facilities for the cleanup of oil spills. The ODD fund also supports oil spill prevention efforts, including the Safe Tank Program, a heating tank replacement program for low-income homeowners. What the OPC fund does, it provides financial support for the DES spill response and prevention programs. Okay. The bill as amended makes 5 changes to existing statutes, RSA 146D, and RSA 146A. It changes the due date of the annual report for the ODD fund from October 1st to March 1st. This allows a more realistic timeline to include previous fiscal year financial information, board review, and discussion and approval. The bill raises the reimbursement cap for the board can provide from the ODD fund for the replacement and removal of home heating oil tanks where the owner has a financial need. Okay. Current limits are not sufficient to cover the actual cost to complete this work. The bill extends the collection of oil import fees that are directed to the ODT fund. These fees will expire on July 1st of this year. These fees sunset every 10 years to prompt a review of the revenue requirement to implement RSA 146D and to maintain the financial viability of the ODT fund. The amendment, which I passed a copy out to you, is 2025-1241H. To this bill will change the effective dates, resulting in the continued collection of the oil import fees at current rates for 6 months. This will provide the Department of Safety and industry sufficient time to implement the new fee structure, which will be effective on January 1st of 2026 now. The Department of Safety needs to update licensee forms that require submission and approval through the Joint Legislative Committee on Administrative Rules, JCAR, before they can be used. Department of Safety needs to notify licensees of the new fees so they would be aware of the fee changes before their effective date. The bill adjusts the per gallon import fee amounts that fund both the ODD fund and the OPC fund. These fees are for 3 individual types of oils: gas and diesel, fuel oil, motor oil, and then a fee on all that's imported into the state. Please consider voting OTPA on HB 658 for raising the cap on certain reimbursements from Oil Discharge and Disposal Cleanup Fund, reauthorizes collection of oil import license fees, and adjusts the fee amounts. Thank you, and we have people on board today that actually really know the details of this and provided a lot of the support on this. And from DES, it's Jennifer Motz and Robert Bishop, and members of the committee, the chairman, Thomas Foley, and I believe the vice chair is probably back by now, Senator Howard Pearl. Is there any questions for me, or you might want to save them for the people that really know what they're talking about?
I'm sure you know what you're talking about, Representative. Further questions from the committee? Seeing none, thanks very much. Senator Pearl.
Thank you.
Good morning. Good morning, members of the Ways and Means Committee. For the record, my name is Senator Howard Pearl, representing District 17, and I live in the beautiful town of Loudoun. I'm here today to support House Bill 658. Representative Edgar did a great job in explaining the details, and there are other members of the committee here as well. I only have a brief amount of time, as I'm unfortunately chairing ED&A, and we have a pretty hectic schedule, but just want to tell you that, this bill is the result of a 10-year audit that we did, and we occasionally need to recategorize our fees so that they align with the way the money is spent, so that those funds are being used as they properly should be and coming from where they properly should be. So again, the details, there's some other folks that will really get into them, but we have support of like the New Hampshire Motor Transport Association, folks like that. They understand what we do, and they're supportive of the bill as we have drafted it. So I would encourage you to pass it. Thank you. All right, thank you.
So I got one.
Oh, you have?
Oh, no, I get you for a chance. I don't get this very often, so I might ask you a crazy question. No, I'm just kidding. So my understanding of the testimony was, again, some of these are going up, some are going down. The whole point of this is to align where the actual problems are, so that we have enough revenue where the problems are created based on the fuel type to be able to solve those problems.
Yes, this will realign it with the way we project the money will be used within the diverse amount of funds that fall under this program.
Great. Thank you. Any other questions?
Not for,
All set. Thank you, Senator Pearl. I was going to ask you about the osmosis process on maple syrup, but I chose not to.
yes.
Yeah. Next up will be Tom Frawley.
Chairman of the Department of Environmental Services, who probably will be able to answer a lot of detailed questions.
Yes, why don't you come on up?
Good morning, Chairman Lang, committee members. My name is Robert Bishop. I am the administrator of the Oil Remediation and Compliance Bureau at New Hampshire DES. I'm joined by Jennifer Martz, who is the supervisor of our fund management section. The fund management section is administratively attached to the Oil Fund Disbursement Board. Provide a little bit of background on the import fees. The import fees on the different types of petroleum were originally established in 4 separate statutes. In 2015, the statutes were consolidated to provide the Oil Fund Board with efficiency and flexibility in the management of the funds. The ODD fund, so that ODD fund, was originally established in 1988 with a fee on gasoline and diesel fuel. This was followed by legislation in 1995 to establish a fee to address motor oil spills. And legislation in 1998 established a fee to address fuel oil spills. Those were all combined together, consolidated in 2015. The Oil Pollution Control Fund, OPC fund, to support the implementation of RSA 146A was established in 1985. So it's a little bit older. The current fees of 1.5 cents per gallon on gasoline and diesel fuel and 4 cents per gallon on motor oil were established in 1995. Those fees have not changed since 1995. The current fee of 1.25 cents per gallon on fuel oil was established in 2009, and the current fee of 1/8 cent per gallon on all other oil was established in 2003. So those current fees date back to that time. To address the 10-year sunset of the oil import fees and determine what will be needed to address petroleum contamination in the future, in 2024, the Oil Fund Board contracted with an actuarial firm, Taylor and Mulder. The actuarial firm was tasked with forecasting for the next 11 years, encompassing the 10 years of this proposed bill. Forecasting for the next 11 years, ODD fund spending by project, which is based on the different types of oil that are spilled, Oil Pollution Control Fund spending, and oil import volumes. Actuarial firm made these projections using historical project remediation expense information, DES spill response information, historical oil import information, U.S. Energy Information Administration fuel usage data and predictions, and U.S. Department of Treasury data. They pulled on data from a number of different sources in order to make their projections. The actuarial firm applied predictive analytical and actuarial techniques to propose oil import fees that are adequate but not excessive to fund the projected expenses over the next 10 years. The actuarial firm determined that an 8% overall increase in oil import fees was necessary to maintain financial viability. The board agreed with this finding and worked with the actuarial firm to land on the fee amounts proposed in House Bill 658. Representative Edgar described the purpose of the ODD fund and the support that it provides. To provide context, I'll provide a few stats and examples. Over the history of these funds, there have been 4,780 projects that have been funded to help with this contamination caused by petroleum. In the past, going back to 1988, when the ODD fund was first established, underground storage tanks, they were all made out of metal and they leaked. At this point in time, we have regulations and new standards of tanks, and we get very very few new releases. But we are still dealing with historical releases, and we are also anticipating new releases from other sources and a few releases from those leaking underground storage tanks. In the recent history, so far to date in fiscal year 25, the Safe Tank program, which will replace substandard tanks, so that's not just any tank, but it has to be substandard for low-income homeowners, has replaced 202 tanks. Fiscal year 24, 313 tanks were replaced. Those were tanks that were imminent release, or a release was imminent from those tanks. Examples of the putting properties back into productive use. A recent example that just opened in 2024 was the former Manchester Mills property owned by Ben Gamache in 2017. He sought fund eligibility for property on the corner of West Auburn and Canal Street in Manchester. That property was recently redeveloped into a 250-unit multifamily residential structure with mixed-use commercial. The ODD fund assisted here with the removal of 603 tons of oil-impacted soil. There's groundwater monitoring going on, and prior to that project, there were exceedance in the groundwater of benzene and naphthalene, common contaminants to fuel oil and gasoline. And with those being removed, recent groundwater monitoring data shows that the benzene and naphthalene is below the standards that are set for groundwater. Highlighting that project as one example of many examples where the oil fund has assisted in cleaning petroleum contamination at a site to allow for it to be redeveloped and go back into beneficial use. Jennifer and I are happy to take any questions that the committee has.
So questions from the committee, Senator Roosevelt.
Thank you, Mr. Chairman. I have two questions. First one is, are either of these funds subject to the 5% sweep that the House put in its budget for dedicated funds?
The answer to that is yes. The Oil Pollution Control Fund, the fund that funds spill response efforts at New Hampshire DES, is subject to that. The ODD fund is not.
Do you know how much money is in that fund so I can figure out how much 5%?
So I believe that the 5% is on revenue into that fund, and that is at approximately $2 million a year. So we'd be looking at
5% of
Yes.
2 million. And if I could follow up, I noticed that in fiscal year 28, the revenues really are down quite a bit from 27. And I'm just curious why the actuaries thought that was going to be true.
the actuarial firm using the historical oil import data, so actual gallons imported, and the US EIA data with future predictions are looking at a decline in the overall import and use of petroleum products going forward. It's declining the decline is very slow that they've predicted there. It's not precipitous, doesn't go right off a cliff, but it does decline and continues to decline per their prediction over the 10-year period.
It's pretty significant year over year. I'm sorry. So was the oil cleanup fund or which fund was subject to the 5% sweep?
The Oil Pollution Control Fund,
Okay.
the OPC, and that is the fund that funds spill response efforts for the department, as well as prevention efforts.
So one more question.
Absolutely.
Good. Without that 5% of 2 million, would you have enough money to pay out these increased awards for tank removal?
I believe that we will, and with that oil pollution control fund, we budget in there the ability to respond to the first 3 days of a major coastal oil spill. We have large oil terminals that bring tanker ships, bring oil to those terminals. And so if we had a spill from that site, we're looking at about a $500,000 per day burn rate. And so we are looking to cover that with a balance within that oil pollution control fund.
Thank you.
Further questions from the committee? I guess I just have one. I'm looking at the bill and I didn't realize it, but in page 2, line 23, we have $125,000. That's just a direct transfer of funds from this revenue line into the general fund. Do you know when the last time that was changed?
I do not know the last time that was changed. It has been within these funds going back over 20 years from what I've looked at, but I don't know that it's been changed.
So my one follow-up question was also, so your revenue, based on your revenue numbers, what is you gave us what the out is, the in is, how much money we expect to bring into revenue. What's the outlook like on an annual basis? How much do you spend out of that fund on an annual basis?
So we spend a $12.5 million annually in reimbursements. And so that's going directly to corrective action, cleanup of contaminated sites, and combined the administration of oil pollution control fund, OD fund, and prevention efforts supported by those funds, as well as response efforts. I believe the combined amount that is appropriated, or has been appropriated in previous years, is about $6 million.
How much?
About almost $6 million. Not quite.
So 12.5 on corrective action, 6.6 million on what? Trying to understand what you're telling us.
On the administrative expenses for the oil discharge and disposal cleanup fund and the oil pollution control fund. This is what's put into the House Bill 1 to support the prevention efforts, the spill response efforts, the administration of the fund.
Further questions from the committee? Seeing none, thank you very much.
Thank you.
Tom, did you want to play cleanup?
Sure.
Good morning. Thank you, Mr. Chairman, members of the committee. My name is Tom Frawley. I live in Lyme, New Hampshire. I'm chairman of the Oil Fund Board and have been on that board for over 20 years. I also own and operate a petroleum distributorship that owns and operates convenience stores and supplies several dozen independent customers, individual owners, operators throughout New England. So as the chairman of the board, I wear a couple of different hats here. So as chairman of the board, I can say that our 12-member board does support this legislation. I can also say that as past chairman of the New England Convenience Store Energy Marketers Association, which represents about 950 individual store operators and owners, industry also supports this legislation. It's been a critical part of why New Hampshire stays having a reputation of one of the best states in the country at managing these funds is because of the way the fund is operated over several decades. I'd be glad to answer any questions of anyone, but just wanted to, you have my written testimony. I'd be glad to answer any questions.
Questions from the committee? Do you happen to know the balances of these funds?
I do not, but the folks sitting behind me do.
Okay. Thank you. Seeing no further questions, you're all set.
All right. Thank you very much.
Is there anybody else who wishes to speak on House Bill 658? Seeing none, we'll close the public hearing on House Bill 658. Here. Next up, we're gonna open up a public hearing on a non-germane amendment on House Bill 737. And I'll have the members, hold on, I gotta get the right amendment. All right. So in front of you, you should have a couple amendments on this bill. The one we're taking up is the one that is, let's see, I believe it's Sonia, 1468, is that the right one? 1468 is the non-germane amendment, the other two are germane, so we'll take them up as we open the bill later. But on the non-germane amendment that's being introduced, this is introduced at the request of lottery. It's just some cleanup. In the last few years, we've been making gaming license, multi-year licenses. So I need to pass out the copies of 1468. So in short, what this bill does is just does away with the annual requirement, creates a 3-year requirement, and then adjusts the licensing accordingly. That's what the bill does. Instead of making an annual license, an annual filing, it makes it a 3-year filing. However, understanding that if there's change in ownership, or as you'll read in here, someone gets arrested, there's notification requirements to lottery within that 3 years if that happens. And they would, in the case of change of ownership interests, and new owners would still have to go through a new process for the background checks and everything else. So just on the new owners, not the entire organization. So, Charlie, would you like to come up and speak? Or you're throwing Valerie under the bus. Valerie, you would like to come up and speak. So again, the idea behind this, I drafted this at lottery's request to bring it in this year so we could move on it.
Good morning. My name is Valerie King. I work for New Hampshire Lottery. This amendment was requested by us. We've had, in 2023, the law was changed from an annual license to a 3-year where you don't need a criminal background, but you still need an annual attestation saying you haven't had a criminal conviction and the payment of the license fee. We've had a lot of confusion with licensees not understanding that they still have to pay annually and submit this paperwork. It's been very confusing, and it's even with notifications, we still get a lot of licensees who aren't annually submitting their documentation and payment. So we've requested this to make it a true 3-year license. We think that would be easiest for our licensees to be able to accommodate.
Questions for Valerie? Seeing none? Oh, yep. Senator Murphy.
We require Keno operators to submit an annual license application, right?
This is specific to games of chance, and Keno is not included in this.
I'm just wondering why we would have a license that's annual in one case and 3 years in the other case.
This was an amendment that the original 3 years wasn't something that we asked for. We're just asking now to have a true 3-year rather than a 3-year no criminal and then annual attestations and payments.
Thank you.
Any further questions from the committee? Seeing none. Thank you, Valerie.
Thank you.
Anybody else to testify on Amendment 1468, non-germane amendment, public hearing? Seeing none, I'll close the public hearing on the non-germane amendment, and I'd entertain a motion to go into executive session. It's been moved by Senator Rosenwald, seconded by Senator Benton. All those in favor of executive session, say aye.
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 All those opposed, say nay. The ayes have it. We are in executive session. So let's talk about some of the bills we have open, I think that we might be ready for. So the first one I'll take up is 163, the state funds bill. So if you remember, we had this bill, there was no opposition to the bill. There was one correction that was requested. Senator Rosenwald and I spoke about it, and Senator Almy had a problem. They wanted a source for funds, which have now been identified with the amendment 1336 that I provided. That's for another bill. So if you look at 1336, we just added the language. It says that the monies in this fund shall be non-lapsing and shall continually be appropriated by the Department of Military and Veteran Services, this fund shall be used to supplement general funds provided to manage and operate the facility related to rentals, to rent from other federal program income. Agency income identified by the Chief Financial Officer of the National Guard as eligible for this fund shall be deposited into the fund. So it just creates, if they have funds that come in, we'll deposit into this fund. It basically allows them to use it if the agency generates the fund, the money. Again, this was requested by Representative Almy, who is the prime sponsor of the bill that we deal with this. So is there any other discussion on 163? Seeing none, I'll entertain a motion for Senate Bill, House Bill 163. Been moved by Senator Fenton, ought to pass, seconded by Senator Murphy. I'll offer amendment number 1336 to the committee. We just had discussion on 1336. Is there any further discussion on 1336? All those in favor of adopting amendment 1336 signify by saying aye.
Aye.
All those opposed, nay. Ayes have it. The bill is amended. Is there any further discussion on 163 as amended? Seeing none, all those in favor of auto pass as amended signify by saying aye.
Aye.
All those opposed, nay. Ayes have it. It's been moved by the consent by Senator Fenton, seconded by Senator Rosenwald. Any further discussion? All those in favor of consent, say aye.
Aye.
All those opposed, say nay. Ayes have it. Senator Fenton, you get to take this one out. Second bill disposed of. Next bill, take up. Let's take up 591, expanding the hours of gaming hours, the casino, Keno.
591.
Because you remember, this was a pretty simple bill. Originally, they put down the exact hours of operation that Keno could run in the bill. We amended it just to say if the business is open, it can sell Keno. That's what the amendment does, 11. You have the amendment? Amendment number 1129. So it just changes it. If the business is open, it can sell Keno.
I move all to pass.
That's it. It's been, on a pass has been moved by Senator Murphy, seconded by Senator Rosenwald. I'll introduce amendment number 1129. That changes it to basically when the business is open, you can sell Keno licenses. Any further discussion on the amendment? All those in favor of adopting amendment 1129 signify by saying aye.
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 All those opposed, nay. Yeah, so he made the motion about a pass. She seconded it. I offered the amendment. We just passed the amendment, and now the bill is auto pass as amended. Any further discussion on the bill? Seeing none, all those in favor say aye.
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 All those opposed say nay. Ayes have it. Entertain a motion for consent. Moved by Senator Rosenwald, seconded by Senator Murphy. All those in favor of consent say aye.
Aye.
All those opposed say nay. Ayes have it. Senator Murphy, you get to take it out. You made the OTP
Good
motion.
times.
That's done. Let's take up 451, which is the paint bill. And I'm going to make a motion of re-refer.
Second.
I have it's been moved by Senator Lang, seconded by Senator Murphy on a motion of re-refer. Just as a comment, the industry's trying to work. The biggest conflict here is the fact that somebody who doesn't participate in the program can't sell in the state of New Hampshire, period. And so the industry's trying to work that out to see that we have some specialty paint manufacturers that are a little bit of a problem in this bill. And so we're going to let the industry do its business, have them come back with some recommendations for us, and we'll take it up later this year. I'm good. All those in favor of re-refer, say aye.
Aye.
All those opposed, say nay. The ayes have it. And the bill is re-referred. else we got here? I'm sorry? Senator Roosevelt, do you want to argue on the floor or do you want to allow consent?
Well, I certainly don't argue it on the floor, but maybe somebody else can.
They can take it up consent.
So they can.
So Senator Roosevelt moves consent.
No, I don't.
Oh, yeah, I had her close. So I'll move consent, seconded by Senator Sullivan. All those in favor of consent, say aye.
Aye.
All those opposed, say nay. Okay, we'll ask for more consent.
Yeah.
So we'll leave it on the regular calendar.
Oh, we don't have to be unanimous.
For consent, you have to be unanimous. For the underlying motion, you don't have to be unanimous.
We changed the rule.
No, the rule was, it used to be you had to be unanimous on the underlying motion
And everyone had to be.
and everyone had to be present in the room. Now we allow you to be divided on the question, but still allow consent. You want to leave it on the regular? Yeah, you're going to leave it on the regular calendar. That's where you referred. Let's take up the homestead.
Senator, can you, that was a 4-1 on,
4-1, yeah, so it's not on consent. So it
who's
has
going
to,
to take that out?
I'll take it out. Let's take up homestead 617, we just heard this morning. So, I think in general, everybody was okay with the bill. The only difference, we were having a little discussion around how much. $1 million was a little steep, I think everybody felt. I did develop an amendment based on the 500,000, but based on a question that Senator Rosenwald asked, I am going to ask if we do adopt the amendment, I'm going to make one further change to the amendment as a committee amendment. I'm just going to strike by a married couple from my amendment, which basically just says they can claim up to 500,000. If there's any individual has 250, because we allow up to 500, that indicates that you have two unmarried people in the house that both have an interest in the house. There's an amendment, you should have 1403. There's an amendment that I adopted. Yep, that changes it to $250,000 per person or a maximum claim of 500,000.
So I'll move all to pass.
So wait, I have a question.
Well, let's go, we have to pass, we'll go into discussion. So ought to pass on 617 has been moved by Senator Murphy, seconded by Senator Rosenwald. It's open for further discussion and amendment. You want me to take up the amendment first?
I would do the amendment, and I've got a committee, we can do a committee amendment.
So let's take up amendment 1403. I'd move adoption of amendment 1403. Is there any further discussion on the amendment?
Yes, I wonder if we should ask the Department of Justice to clarify trust. What kind of trust is included in this?
So the argument is on line 21 of the original
Like
bill.
whether we could just say revocable or what, because there are different kinds of trusts and apparently they're not all included, according to Mr. Tamposi.
Right. I guess I understand the question. I'd almost kind of want to leave it up to the attorneys to fight it out. Remember, it's a debtor's going to have to say that's a non-qualifying trust and therefore exempt from the housing and let them make that call rather than try to define something that we might miss and the law might change. Something later on might become a qualifying trust, but now not a qualifying trust. And if we start defining what those are, I think it creates a bigger problem. So we have to keep coming back to the law to change it each time a trust becomes qualified or unqualified.
Could I also question whether we need the sheriff's notice? Because it seems like it's new, and I wonder if it's going to add cost to the county.
So which line, where are you talking
Well,
about?
the whole sheriff notification.
So I don't see a sheriff's notification. If you look at line 15, right, it's notice by certified mail. It just talks about the sheriff in the notice, but it's not a notice by the sheriff.
But you have to notify the sheriff. And what are they going to do with these notifications? I'm just wondering if it's gonna add cost to the sheriff's department. Then I'm looking at starting on line 29. You
Right.
must notify the sheriff.
But everything in from line 16 to line 36 is just what the certified mail notice must say. Doesn't require the sheriff to serve that notice. It says it'll be certified mail. The following notice by certified mail, line 15, and then it defines what the notice is. And this just says that if I'm the homeowner and I'm going to sell my house before something or other, I have to notify the sheriff. It doesn't make the sheriff do anything, it makes the homeowner do something.
True, but it makes the sheriff get a piece of paper, and what are they gonna do with it? Are they just gonna shove it in a drawer? Or are they gonna have to create some, database? It's just a question of whether that is necessary and whether it could possibly increase costs to county property tax.
So again, as I read this already exists, right? So this, if you read it's number 3, line 11, it's amending an existing RSA, and the only thing they amended was the dollar amount. I believe that's already
Okay.
standard practice. So again,
Well,
nothing
in
new.
that case, fine.
So I'm going to move amendment number 1403. Is there any further discussion on amendment 1403?
Yes. So the 250,000 for one person. So when we're talking about the widows that were here, so they've actually now they're a single person, right? Because they're widowed, but so they will have the husband's debt, but not their equity. So in the housing price, in the housing, we are with housing right now, right? I think $1 million is too high, but I think 250 might be too low.
For an individual.
Yeah, and a median household in Manchester right now is about 449, right?
So remember, we're only protecting the equity,
Right.
not the underlying debt, right? So again, that $400,000 house has a $300,000 mortgage underneath it. The liability that a creditor can attach is only the $100,000 on top, and that will protect it.
I'm just gonna go on record and say I think it's a little low.
Well, let's take a motion on the, vote on the amendment. All those in favor of amendment 1403, say aye.
Aye.
All those opposed, say nay.
Nay.
The ayes have it. The amendment is adopted. We're now on a motion of auto pass as amended. I'm going to further amend it by striking on line 14 of the amendment by a married couple. So it would open the door to allow unmarried couples who have an invested interest in they have tenant interests or whatever in the property, to be able to maintain, both have a homestead right.
Mr. Chairman, there's a fundamental question here of whether it makes sense to, the underlying bill that we just amended was $1 million flat.
Yeah.
Might a good compromise position be $500,000 flat instead of treating married couples or couples separately than individual homeowners?
Well, that's why I struck the married couple. I just wanted to be homeowners, right? So again, unmarried couple.
But should we
who
have
might
two
have
different
joint
numbers
interest
or
in the
one
property.
number?
What's it?
Should we have two different numbers or one number is the question. What's the case for two numbers?
So again, if I'm single and I don't have a spouse and I'm living in my home, I don't get the full $500,000. I get $250,000 of my equity protected. If I'm unmarried couple that own a house, we both have a vested interest in the outcome, but we may not be married. But they will allow that couple to still claim up to $500,000. Each person gets a $250,000 equity is what we're saying.
So I would agree with Senator Murphy, because I think now if we do that, we're muddying the waters. Like, who's to say someone doesn't slide in to live in that house so that they can take advantage of the $500,000, right? So if we made it $500,000 flat, regardless of who lived there, I think it would get rid of that scenario that might happen, and
We just
be
have to protect,
more
we have
fair
to
across the
protect
board.
against stacking. Right, that's my concern. How do we protect against two people living in a home, each claiming $500,000? the max, that's what, I think that's what this says in line 3, that just says your maximum amount of exemptions, 500. I mean, we could say every person is equal to 500,000 and then cap it at 500,000, which is essentially only one person can claim the credit. I don't know how that plays out when you've got a spouse whose husband died and the loan was in the house is in the husband's name, or the wife's name and the wife dies, and protect that person. But again, I was just trying to sort of the Rosewall problem. I just didn't want to make marriage being a qualification for both persons to get the exemption. That's all I was doing by trying to strike that line, is to make it clear that there are two. You can go have up to 2 exemptions, up to a $500,000 amount. It doesn't matter whether you're married or not. Right? You'll have to prove you have an interest in the home to claim it.
What happens if you have two people who own a home? They're not married, let's say. One of them goes to bankruptcy. What happens if they sign over their interest in the home to the other person? Then by eliminating the 250 for one person, we shield more of the value of the home, but it seems almost like a bait and switch.
Well, I think bankruptcy laws have, if I remember right, from my days as a cop, bankruptcy laws have issues around you can't change ownership of property within a certain period of time of filing bankruptcy.
Once things have been initiated, basically everything's locked in. All the assets of that person's are locked in until the.
I think even actually look back a certain period of time to see, as you're getting ready for bankruptcy, you don't transfer ownership of property to hide it and shield it. We do the same thing in healthcare. When someone goes to a nursing home, there's a look back period to make sure that people lived and shipped assets and then claim on board.
But in that case, we go after the surviving spouse.
Right, in this case.
After the death
Yeah.
of the person in the nursing home. So we do estate cover.
So again, I don't know that applies as far as transfer of ownership that you were speaking about. Again, my only reason we adopted the amendment, my only reason was I wanted to strike that the people had to be married and and by saying that you can have a maximum of 200,000, it means 2 people can claim the ownership at $250,000 each. And again, we're only talking about the equity portion of the debt, because the bank is in first position for all of that, for the other ownership based on their debt that they've already under the mortgage language. So,
Mr. Chairman,
Yeah.
if in your amendment, if we strike the words for a married couple,
Yeah.
we have sort of an incomplete sentence because it just ends with 500,000.
no, it doesn't. I didn't say maybe help. So the sentence would read, notwithstanding paragraph 1, only one homestead exemption totaling no more than, well, I guess we have to get rid of that one. That 500,000 may be held or claimed, or 250,000 for a single person under the section. So I actually think you're right. We have
And
to
it's in
strike the
the
word one.
sheriff.
You think so, Pete?
Claimed by a couple.
It comes in down here too. So it's in a couple of
Yep.
places where
So
we could
let's.
say 2 individuals jointly owning.
So again, on line 13, I guess I'm going to amend, we'll strike the word one.
Like-
Homestead exemptions, S, totaling not more than 500,000 may be claimed, held or claimed, or 250,000 for a single person. Does that make sense?
Ah. And then if 3 people own the house,
You only
it's
get
still
500,000. Doesn't matter how many people are named. It's be 500,000 your maximum protection.
Mhm. We also have to do that down on
Yep.
lines 27 and
What
28.
do you guys think?
Can we hold off on this?
Sure. So just remember, we have to remember the position we're in. Right now, we've adopted the amendment. We have an OTP motion pending with as amended. And that's when we come back in, that's where we're going to be the starting point is.
Yeah.
For us. And we can hold it next week. We're going to be back next week for revenue reviews. So we can take it out then.
Thank you.
Let's take up the oil we just heard.
I'm sorry, which one?
The oil discharge, 658. So as we just heard, this bill came out of the commission that manages the oil distribution fund. The idea around the changes to the assessments are making sure the assessment is paid by the correct industry so that the gas people aren't paying for fuel oil spills. And that the fuel oil companies and the assessments they pay for their importation of oil pays for their fuel oil spills. So that's what the intent, as I understood it, coming out of the committee was that that's what they were trying to do, is just realign, some go up, some go down in the end to make it. The one thing I was interested in was there's one line in there that doesn't sound like it's been changed. That was the $125,000 general fund appropriation that this fund delivers. It has a $17 million revenue stream roughly coming in and less than that going out.
Well, we have two people on this committee that serve on finance. I'm sure they'll take a hard look at that number.
That's what I'm gonna do. I just wanted to call that out. That's all. Might be a place where I want to relook at and see what's going on.
I was
But we're
going to
gonna-
ask that you make sure that bill goes to finance.
Yeah, so Sonia, do you know, is this an early bill and have to go to finance?
It has an FN.
It has an FN, so I'm assuming yes.
Yeah, but it might be that. But,
And I'll make sure Jim doesn't wait.
yeah, because it's also got that 5% sweep, which is
All right.
another 100,000.
I'll make a motion of ought to pass.
Second.
It's been moved and second ought to pass on House Bill 659. I'd ask that we take up a committee amendment, because we can't actually take up a House amendment. We adopt a committee amendment that's similar to House Amendment 1241, which just changes dates. They needed some implementation date changes. So it'll be a committee amendment that'll need to be drafted. That's same as House Committee Amendment 1239, 1241H. Does everybody have that amendment, understand that amendment?
Yeah.
So we adopt those changes. All those in favor say aye.
Aye.
All those opposed say nay. Ayes have it. We now ought to pass as amended. Any further discussion? Seeing none, all those in favor of ought to pass as amended say aye.
Aye.
All those opposed, nay. Ayes have it. Motion for consent. It's been moved by Senator Roosevelt, seconded by Senator Sullivan to be put on consent. All those in favor say aye.
Aye.
All those opposed say nay. And Sonia, I'll take that one. All right, last one we can take up is going to be 737. So this bill is, if we remember right, talks about games of chance and creating a local option to allow communities to prohibit games of chance locations in their community if they so choose. I have there's a couple of amendments to this, one of which is the non-germane amendment we heard today, 1468. Another one is amendment by Senator Roosevelt, Amendment 1459, which just fixes some problems with how it gets on the ballot process. And then the last amendment is one that was delivered today about Keno. I did check and confirm that it's a gambling and it's a local option, so therefore it's a germane amendment. I don't need a separate germane amendment hearing, even though it's about Keno versus games of chance. The general topic of allowing opt-in versus opt-out it falls within germaneness of the bill. You should have 1575. Sonia, do you pass that out? So it should be somewhere in your stack. So this bill basically treats now, if we adopt 737, which is an opt-out provision, allows towns to opt out of games of chance. This does the same thing to Keno. It inverts the process we have now, which is opt-in, and it says from now on, Keno will be legal everywhere unless a town chooses to opt out. I will tell you that the amendment is drafted with an 18-month delay before it's legal to give towns a chance to get it on their ballot to prohibit it if they want to. So it allows for next year, if we pass this, that next year they could prohibit it before it became legal in their town. And then if they don't act next year, then it's going to go on the ballot. It's going to be legal in their town going forward, and anybody who's eligible for a Keno license would be eligible regardless of the town. Regardless.
When did it become?
Sure. So if you look at the last page, page 2, sections 1 through 4, which is the process to allow a town to put it on their ballot to prohibit, goes into effect immediately. However, the actual converting it from a prohibited town to a licensed town, to a legal town, doesn't happen until January 1 of 27. Right?
The cities,
Everybody has time to get it
the
on their ballot.
cities could get it on their ballot.
Right. So again, I think we should have one process for how we deal with gaming. We either allow them all opt-in, we allow them all opt-out. I'm choosing to make towns, they don't want it, they have to choose not to.
You know how I appreciate that consistency, Mr. Chairman. I look forward to taking that same approach throughout our dealings together here.
So, all right.
I will move on to tax.
So 737 is moved ought to pass. And we'll start with amendment number, what's on the Rosenwald amendment? Let's start with amendment 1459.
Thank you, Mr. Chairman. So this amendment is really technical, and it just speaks to the fact that a city could have the legislative body vote to put the question on the ballot in addition to receiving a petition of 5% of voters. So the towns, they operate in ways that I don't fully understand, but cities would have both of the ways we typically allow questions to go on our ballot. And that's all it does. I am going to suggest a further committee amendment later.
Okay, we'll get to that.
That's
Let's take
all
this
it
up
does.
first.
Happy to answer questions.
All those in favor of amendment 1459 signify by saying aye.
Aye.
All those opposed, nay. Ayes have it. That amendment is adopted. Next, we'll take up the non-germane amendment. We heard 1468, which is the licensing change for lottery. And I'll introduce that amendment 1468 and open for discussion. Any further discussion? Seeing none, all those in favor of amendment 1468 signify by saying aye.
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 All those opposed say nay. The ayes have it, and 1468 is adopted. Last one we have, I'll introduce 1575. This is the Keno option we just spoke about. It adds to the bill and allows for towns to vote to prohibit and extends that out before we make it legal everywhere to give towns an opportunity to get it on their ballot to continue to prohibit if they want to do that. Any further discussion on 1575? Seeing none, all those in favor say aye.
Aye.
All those opposed, nay. Ayes have it. And Senator Roosevelt, you had a further amendment.
I do. I'm still uncomfortable in the original bill.
The original bill?
Language, well, I think it's, I think it's just in the original bill. It might be in some of the amendments. With the question of, on page 1 of the original bill, line 21, additional brick and mortar games of chance. Because I think we know what that means, but I'm wondering if we would consider, instead of brick and mortar games of chance, saying with a, games of chance operations with a physical location. That's all. I don't know that most people think about bricks and mortar the way we do.
So I would question, Senator, if that would open up, if they had a physical location, would that also open it up to things that are online or whatever that are attached to that business because it does have a physical location, but they are not operating from a physical location?
Well, I'm not sure that it would open it up any more than the original language does.
So
I
what
mean,
if we,
if we said additional games of chance, what I'm suggesting is additional games of chance operations with a physical location. Like in town, or
one more time, read line, so we're talking about changing.
so striking brick and mortar
21, striking brick and mortar.
and saying, shall we prohibit additional games of chance operations with a physical location? And I'd probably say in Manchester or in Nashville. That's all. I think it's just more clear than brick and mortar.
Shall we prohibit additional?
I think it's a fairly harmless amendment.
Yeah, I do too. I just want to make sure the sentence reads clean, that's all.
I mean,
So, shall we
it's your-
prohibit additional games of chance operations with physical
location.
facilities?
In the,
In
we
the-
could
within
even
the city.
say in the city or town. And I think it's just more clear and comprehensible. I
So-
think consider it a friendly amendment.
Yep, no, I agree. I think we strike brick and mortar on line 21, and on line 22, it says games of chance operations with a physical facility within our city or town.
Yeah, so,
Does
yeah.
that work?
Yeah.
Okay. Sonia, you got the gist of that amendment? Okay. So first page of the bill, line 21, we're going to strike the word brick and mortar. And then we'll finish, after that, we'll finish it, games of chance operations with a physical facility within our city or town.
Are you saying our?
Whatever the rest of the sentence.
Or
Or town.
in the,
Yeah,
yeah.
Yeah.
In our city or
Within
town.
the
Yeah.
city or town or city. We're just adding the word with physical facility after operations.
Got
it. Everybody clear what the amendment is, the additional committee amendment is? All those in favor of the additional committee amendment, say aye.
Aye.
All those opposed, say nay. We are now on the bill as amended with all these amendments. So we'll be adopting amendment number 1575, amendment 1468, amendment 1459, in addition to the voice of committee amendment. Is everybody clear on the question? All those in favor of auto pass as amended, say aye.
Aye.
All those opposed, say nay. Ayes have it. Entertain a motion for consent. Senator Sullivan moves consent. Senator Murphy seconds. All those in favor of consent, say aye.
Aye.
All those opposed, say nay. And Sonia, I'll take that one out.
Perhaps we can consider making the Keno applications good for 3 years.
I will. Actually, I'm happy to sponsor or co-sponsor that. We'll talk to Charlie next year, get that cleaned up. Yeah. I will say, I also wonder, what is your, well, let's get off that. Let's finish this and then I'll have a conversation about that. We are holding off on 617. So the other, we have, well, basically have, at this point, we'll have 4 bills. We got 2 new ones from the House, right, Sonia, that we haven't heard yet. We'll be hearing next week. That was sent over the last day of the House session. So we have 2 new public hearings we'll be having next week on bills. We also have 274, which in light of what we just did with 737, I'm just going to hold in case we need a bill to do something with, but ultimately I think that's going to be an ITL because we just did the opposite with 737. We have the Charitable Gaming Commission, which I have an amendment to. I just haven't got it drafted yet. So we'll look at that next week. I'll have the amendment. We'll be ready for that one. I'd ask you to come prepared to talk about the homestead rights, and we'll continue the voting on that to take care of that. And then we'll see what the next 2 bills bring for testimony and where we go. So I think we've dealt with almost everything we can deal with at this point. Is there any other discussion or an executive session about bills pending? Seeing none, entertain a motion to come out of executive session.
So moved.
It's been moved and seconded to come out of executive session. All those in favor say aye.
Aye.
All those opposed say nay. The business today being done, we are adjourned.